Hello, this is chapter 3, and now we're going to discuss about resolving disputes. So how are disputes resolved? That's what we're going to talk. And you've seen a while that we have mainly three ways. Um, it's not that you can choose, but three different ways you should be aware of in terms of having disputes resolved. We will start by looking at the alternative dispute resolution methods, which are negotiation, mediation, and arbitration. And then we'll look at the court litigation. And for that, we first need to know how the court system is in Canada. And then we'll be able to look at a court file, how it develops. And then we will end by looking at regulatory bodies and administrative tribunals. Uh, those are also used to solve some disputes in Canada. So for alternative dispute resolution, it's important to keep in mind the name. It is alternative, not mandatory. So it is an alternative as a general rule. It is an alternative to court litigation. So you may decide to go through any of those methods: negotiation, mediation, and arbitration. In very few occasions, the law will require parties, the disputing parties, to try solving their issue through mediation before going to court. Some family issues, some employment issues, those are examples in which parties should go through mediation before they start court litigation. But again, the general rule is that those are alternative methods, okay? And because they are alternative methods, it means that both disputing parties, they need to agree to try solving their disputes through any of those methods, or even all of those if they want. So it means any or all those methods will be in an agreement, will be in a contract, uh, and there will be a clause reading more or less like this: any disputes arising out of this contractual relationship shall be resolved by negotiation or mediation or arbitration. And it could be more detailed. So it has to be agreed between the disputing parties. Here we have just a comparison, and you can read them. And what are some main advantages? Well, the main ones are parties will have control of the solution. Well, let me exemplify this. So you are involved in a very small, light car accident, just material damages, but very little. So you and the other party, you just negotiate. You get a check, $100, $200. It will be enough for your damages. And that is done. You don't need to sue, you don't need to do anything else. Or if you get the wrong products or defective products from your supplier, you call them, you meet them, you email them, and yes, so you have control of the dispute and how you will resolve this. And because of this, you may also have lower costs. An exception would be for arbitration sometimes, because arbitration, both mediation and arbitration, they may be handled by specific mediation and arbitration tribunals, as they call. So there may be costs there, but usually those costs are lower than court ones. And also the goodwill will be preserved. Yeah, so you're not suing. When you are suing someone, it is usually the goodwill is lost. So you just want your lawyers to handle the issue. So yeah, those are some of the advantages. Disadvantages will be that there may be not judicial fairness and impartiality in those processes. So imagine if you're trying to negotiate as a supplier, you're trying to negotiate with Walmart. Your bargaining power is very low. So, and because of the main or because of the characteristic itself of those methods being alternative, there can't be a guarantee of fairness. Okay, and also courts, they have more power to extract information from the disputing parties. So if the disputing party, one of them, does not want to disclose an important document, an important piece of evidence, you cannot force, but courts can. Also, precedents are usually not followed up because precedent is stare decisis, as we saw in chapter 2, is a characteristic of a common law system. So it is specific for courts, not for the alternative methods. So let's look at them. Negotiation, straightforward. So parties will discuss the issue and will try to find a solution. That's it. But what if they find a solution and the party who should perform something based on that solution doesn't perform? Well, then you would need to negotiate again or to escalate to court litigation or eventually go to arbitration. But what I'm saying is, hopefully parties will perform their obligations based on the solution they found. But if they don't, parties cannot force one another. So that's one important aspect here. The solution achieved through negotiation is not binding. In most cases, parties will perform, will comply, but they are not bound to if they don't. Okay? The exception will be if parties sign an agreement based on that solution. But then this will be dealt with by contract law because there will be an agreement. And this we'll see from chapter 6 and on. Mediation is one step further negotiation. And why do I call it this way? It's because parties were not able to, let's say parties are not able to find a solution through negotiation. So they get a third party to help them find a solution. So let me get an example, a family example. The couple, the partners, they are negotiating an issue and they cannot find a solution. So they usually find resort with any of the partner's parents or a church leader or a counselor. So this is an example of a third, usually neutral third party helping the partners to find a solution. And again, the same characteristic as in negotiation. The solution is not binding. Hopefully, parties will comply uh, with what was decided, uh, with was achieved through that mediation, but it is not binding. Okay. And the last one will be arbitration. Well, arbitration is very similar with court litigation. It's still an alternative method, but in arbitration, there will be an arbitrator, and the arbitrator will render a decision. It is the arbitrator who will reach a decision. In negotiation, parties were reaching a decision themselves. In mediation, parties were also reaching a decision, a solution themselves with the help of a neutral third party. But now with the arbitration, parties are just submitting their evidence, making their claim, filing their responses, and then the arbitrator, based on all the evidence that was produced, will render a decision. And here, the decision, which is technically known as an arbitral award, this decision is binding. The losing party has to comply with the decision. And if they don't, the other party may seek the court's help to force the party to comply with that arbitral award. Okay? So arbitration is more adversarial because parties are not actually cooperating. They are just making their claims, submitting evidence, and the arbitrator will make a decision. That decision cannot be appealed. So the merits cannot be appealed. So if you won, you won. If you lost, you lost. There may be some recourses or resources for an arbitration procedure in case the procedure itself, not the merits of the case, but the procedure is not fair. For example, let's say the arbitrator allowed one of the disputing parties to produce evidence, but did not allow the other one to do the same. So there's an issue here in fairness, in equal access. Then that process may be appealed, but not the decision itself. Okay? So those are the three alternative resolution methods: negotiation, arbitration, and mediation. Remember, they require an agreement to be used. And when I say agreement, I'm not saying a contract. What I'm saying is parties, they need to agree. Both of them need to agree to try solving their issue through either negotiation, arbitration, or mediation. Now let's look at court litigation. But before we enter the litigation itself, we need to learn a little bit about the courts. So, first of all, in Canada, the procedures for the lawsuits, they will vary by province. They are very much alike one another, but there's still some variance. There are still some different rules. So if I'm a lawyer here in BC, I need to be knowledgeable about the civil procedures in BC. But then if I transfer to another province, I would need to study those rules again, because they may be a bit different. And as a general rule, trials are open to the public. Some exceptions will be when there's a child involved in the case, or if one of the parties requests the judge to make them confidential. The judge, at their discretion, will decide, will grant confidentiality or not. So it will depend on the nature of the issue. And we'll be mostly discussing about civil matters. And civil here means private. Civil is not the civil law system we saw in chapter 2. Civil here is private. Civil here is the opposite of public. So public law, public matters, here civil matters. So civil matters, they are usually about or between two private persons, or could be one person and a company, an institution, and they are using the court to solve their dispute. So the court is used as a referee to render a decision because, yeah, they are disputing something. And the judge, how will the judge decide a civil matter? The judge will decide on a balance of probabilities. This is very important. So this is the level of proof the plaintiff has to produce. Who is the plaintiff? Plaintiff is the one starting the lawsuit. So whoever sues, whoever starts the lawsuit will be the plaintiff. And if I am suing someone because I'm saying, for example, person B caused me loss, they don't want to pay me, so I'm suing them, I have to prove in court that person B actually caused me loss. And how do I prove this? I prove this on what is known as on the balance of probabilities. It means that based on the evidence produced by both parties, the evidence I produce, the evidence the defendant, the one that is being sued, the evidence that the defendant produces. So based on that, based on the claims, based on the law, the judge will decide on 50.1% to one side or the other. So what I'm saying is the judge does not need to be 100% sure about who has a right, who should win the case. It's on a balance of probabilities. Based on the evidence that is there, the judge believes more that one party should win over the other. Okay? So this is known as burden of proof, and a burden of proof in a civil matter is on the balance of probabilities. Okay? Why is this important? Because the burden of proof in a criminal matter, which we are not dealing with in this course, but I need just to mention to you so I can contrast, I can differentiate to you. The burden of proof in a criminal matter is known as beyond a reasonable doubt. So it is much higher than in a civil matter, than on the balance of probabilities. So in a civil matter, the judge may have some doubts, but on the balance of probabilities, one party should win. Either the plaintiff suing or the defendant, the one sued. But in a criminal proceeding, there can't be a reasonable doubt. If there's any reasonable doubt remaining about the accused, whether the accused committed a crime or not, the accused will need to be acquitted. Accused people in criminal proceedings can only be found guilty when there's no reasonable doubt, beyond any reasonable doubt. And I just told you that in a civil matters, two private parties are involved, one sues the other. In criminal proceedings, the victim does not sue the accused. It is the government, through the prosecutor, who will pursue the matter and prosecute the accused. So in general words, in a criminal proceeding, the victim will only report to the police. Not only, but the victim will report to the police, will present their evidence, their testimony. But they are not suing. It is the government that is doing this. Because it is the government, the one who has the power to send someone to jail, who put someone on probation. And it is the prosecutor that has to produce evidence so that the jury or the judge are convinced beyond any reasonable doubt. If the prosecutor cannot do this, the accused will be acquitted, not found guilty. So this difference between criminal proceedings and civil matters has to be clear in your mind. Because a person may face both criminal proceedings and civil action, a civil lawsuit over the same conduct. How? Okay, let me explain you. Let me give you an example. It is, let's say your smartphone was stolen and you know who stole. So you report to the police and they find who stole your phone, but they don't find your phone anymore. So stealing is a criminal conduct, is a crime. So they found the accused, and the government will pursue the criminal proceedings over the accused. You only report it to the police. But don't you agree with me that you lost something? You had a loss, your phone, your smartphone. So this is dealt by civil courts, not criminal ones. In a criminal court, the accused will be either sentenced on probation or jail based on their conduct. But there's no money, there's no compensation for the victim. Compensation has to come from civil matters, civil proceedings. So you would sue the accused in a civil court in order to recover your loss, trying to recover your loss. So the accused or the person who stole your smartphone, in this example, would potentially face two proceedings, one criminal, one civil, over the same conduct. And by the way, the prosecutor has to pursue the matter, the criminal matter, if they have proper evidence. But you don't have to sue the accused. You may, but eventually you say, no, I'm not suing because the legal costs are not worth, or because the accused does not have any assets to pay you compensation. So why would you spend money with court fees, lawyers, etc.? So you don't have to. You may, if you want, you may. You may sue the accused. Okay? So that's very important. Now let's look at the court system. So as I told you last chapter, in this course we are only focusing on the provincial courts, well, administrative tribunals, and then provincial courts, those in here, and then the Supreme Court of Canada. We are not looking at federal courts, tax courts, or even military courts. So only those. And why do you need to understand this? Well, first of all, your lawyer will be knowledgeable about this. But you should understand. Why? Remember when we spoke about stare decisis? Meaning that decisions from higher courts, they are binding on judges from lower courts. So if you don't know which ones are the higher courts or the lower courts, you cannot apply stare decisis properly. Remember I gave you the example about same-sex marriage in Canada coming from the Supreme Court of Canada, the highest court in the country. If this is the highest court in the country, it means that all their decisions, they are binding in all courts in Canada. Because precedents, decisions from higher courts, they bind the lower courts. And then in each province, we'll have a court of appeal and then lower courts. The Court of Appeal is the highest court within a province. It is still lower than the Supreme Court of Canada, but the highest in the provincial level. So it means that all decisions from the Provincial Court of Appeal, they are binding on the lower courts in a province. See? And then we have the Superior Court and Provincial Courts. They are the lower courts within a province. So let's look at some details of those. The provincial court, this one, the provincial court, the lowest court. So the provincial court is the lowest level within a province. And they will not only, but they will deal with less serious criminal matters, but we don't worry about those because this is not a criminal law course. What is important to us is that they deal with small claims matters. There's a small claim division here in BC. And I'll be mostly talking about BC in terms of provincial courts because they vary from province to province. Even their names are different. So here in BC, in the provincial court, we have a small claims level court division. And they take civil matters up to $35,000. Why is this important? Because in a small claims court, procedures are simpler, more simple, much simpler. You don't even need a lawyer. You can have one, but you don't need a lawyer. So you can do it yourself. You're saving money. Okay? And then we have the superior court of a province. So the superior court, and in BC this court is known as BC Supreme Court. Please do not confuse this with the Supreme Court of Canada. They are different courts. So the Superior Court of BC, the BC Supreme Court, is the highest trial court. So all trials, they will be either in the provincial court for matters that I just mentioned to you, less serious criminal, up to 35,000 or even family issues, or trials will be in the superior court. So they are the highest trial level. And what is a trial? Where the trial takes place, where parties present their evidence, when there's the trial day, where parties can bring witnesses. So we'll see the litigation process, by the way. And the Superior Court, the BC Supreme Court, this Superior Court in BC, they will deal with unlimited monetary issues, over 35,000, and also with more serious criminal issues, a murder, for example. So a trial will take place either in the provincial court or the superior court. But then the party who loses the trial, they may appeal the decision. If you win, you don't want to appeal. You have no grounds to appeal. But if you lose, you may have grounds to appeal. It may be the case that the judge made an error. It may be the case that the judge interpreted the law in the wrong way. So then you have grounds to appeal the decision. When you appeal, you are actually appealing on questions of law. Very, very few occasions you are allowed to appeal on questions of fact. And what are questions of law and questions of fact? Well, questions of fact, they are related to facts. Was the driver drunk? This is a fact. The driver was drunk or not drunk. Was the traffic light yellow or red or green? This is also a fact. How much did it cost to fix your car? This is a fact. You may have an invoice, quotation. What are questions of law? Questions of law are questions related to the law, the legislation, case law. So did the judge apply the proper case law in this dispute? Or did the judge interpret the case law applied in this case correctly, as it is, as it should be interpreted by the precedent. So those are questions of law. They are not related to facts. So when you appeal because you lost the trial, and there may be a legal issue. Legal issue meaning interpretation issue or the case law or the legislation that was used. And then we have the Supreme Court of Canada. So again, just coming back here to this chart, I told you that the Provincial Court, we have the small claims division up to $35,000, or for unlimited matters, unlimited monetary matters, Superior Court. In BC, it is known as the BC Supreme Court. Those two, they are trial level courts, being this one, the Superior Court, the highest trial court. The one who loses the trial may appeal to the BC Court of Appeal, and the appeal will be mostly with questions of law only. And there may be circumstances in which the party who loses the appeal, they can have another appeal to the Supreme Court of Canada. But very few circumstances. When can you appeal from the Court of Appeal? Only if the questions of law are related to the Constitution. So remember, the facts are decided in the trial level. And then the party who lost appeal to the Court of Appeal, questions of law, and let's say they won here. So the losing party in the appeal, if the questions of law are related to the Constitution, they can appeal to the Supreme Court of Canada. So whoever loses the appeal could be the appellant or the respondent, whoever loses the appeal, and only if questions of law are related to the Constitution of Canada or the Charter of Rights and Freedoms, then they can appeal to the Supreme Court of Canada. So the Supreme Court of Canada will hear few cases. Not all cases will reach the Supreme Court of Canada. And cases that cannot be appealed to the Supreme Court of Canada, the Court of Appeal's decision is final and binding on lower judges because of stare decisis principle. Okay? So the Supreme Court is our highest court in the country, composed of 9 judges or justices as they are called, and their decisions are binding precedent. Yes. Why? Because they are the highest court in the country. Okay? We also have this CRT, the Civil Resolution Tribunal. The CRT is actually part of the Provincial Court in BC. And I told you that in BC we have the small claims court, issues up to $35,000. But they have gone even further. They have created this CRT, the Civil Resolution Tribunal, for matters of up to $5,000. So let's say your issue, the smartphone issue, your friend broke your smartphone and your damage was $500. So you don't need to use the small claims court. You can use the CRT, Civil Resolution Tribunal. It's an online dispute resolution system. Very straightforward. Again, you may have a lawyer, but you don't need. I highly recommend you to log on to this website and read a little bit about this. It may be useful to you. It may be useful actually to anyone because we can solve the issues on our own and saving money. Costs are very low. Okay? So those are the main important aspects for the court system in Canada. And again, you should know them because they are related to uh, the principles of common law. So now the process of civil litigation. Before we look at the steps of a court litigation, we need to know about the limitation periods. And what is this? The limitation period is you cannot take long to sue someone. So if you have an issue, you have a matter, and you want to sue, you cannot take, the general rule is 2 years. So you cannot take more than 2 years to sue someone. For employment matters is 1 year. For human rights matters, 1 year as well. It used to be 6 months. So this is the limitation period. If I know I caused you damages, and after 2 years you didn't sue me, I know you cannot sue me anymore. Okay? So that's the limitation period. And jurisdiction, what is this? Jurisdiction is actually where the lawsuit will be started. So will you sue someone where they live, or where they work, or where they were born? So this is the jurisdiction. Which court will have jurisdiction, will have the power to solve the issue? So the general rule here is that the court to assume jurisdiction over a matter will be the one in which the defendant, the person being sued, resides. So whatever companies or people who want to sue you living here in BC, they have to come here and sue you. This is the general rule. There are exceptions to this. For example, land. Let's say you own land, you own a townhouse located in Manitoba. So even though you reside in BC, because your land is in Manitoba, if someone wants to sue you related to your land, to your townhouse, not over other matters, but related to your land, then the Manitoba courts will have jurisdiction over that matter. Okay? So the process of civil litigation, what I recommend you, well, it's important that you understand what those terms are, documents are. So plaintiff, as I said, plaintiff is the one who sues, defendant is the one who's being sued, the documents they file, and until the decision. So you should have an idea of those names and what they are. But instead of discussing the whole process with you, I recommend you watch this 7-minute video made by a lawyer here in BC, and the lawyer will detail all the steps from the statement of claim, the first one, the pleadings, so when you decide to sue someone, until the decision. Okay, so please watch this video. You don't need to memorize the steps, the details. All you need is to have a general, broad idea of how the process of civil litigation is. So I've discussed already about the simplified procedures. Here in BC, they are the Small Claims Division and also the CRT, the Civil Resolution Tribunal. So when we get to the judgment, how is the judgment rendered? The judgment may be rendered by the jury, or, sorry, there may be a jury and a judge in a lawsuit, or only the judge. Parties, they may request a jury, but when they do so, they should be aware that it's going to be more costly to them. So it is very common not to have jury lawsuits. But when there's a jury, the jury will decide only on the questions of fact. And we have discussed this already. So my example here is, was the defendant drunk? This is a question of fact. And the judge will decide on questions of law. For example, what is the case law that has to be applied, or what is the statute that has to be applied in this case, and how it has to be interpreted. When there's no jury, the judge will decide both. The judge will decide questions of fact and also questions of law. Okay? Costs in litigation, they are usually high, and the judge will decide who will bear the litigation costs. Usually, not always, but usually, the losing party will bear the litigation costs. Usually. So when you are suing someone, in most cases, in most civil matters, most, not all, but most, you are seeking damages. You are seeking monetary compensation. So you want compensation because you suffer damages. So once you prove you suffer those damages, the defendant was at fault, the judge may award damages. And there are three main types of damages. There are other types, but the three main ones are general. So general damages are damages that cannot be precisely calculated. Are damages that are related to suffering, pain, could be future lost wages, which will be an estimation. You cannot precisely calculate them. So those are general damages. Special damages are those that you actually incurred. So the invoice for the invoice you paid to fix your car, the cost of a smartphone that you lost or that was damaged, medical bills. So those are costs that you can prove. They can be precisely calculated. And then punitive damages. Punitive damages, they are damages that aim at punishing the wrongdoer, the offender. So back in the 80s, this lady spilled coffee on her lap. Coffee she had purchased from McDonald's in drive-thru. And then she sued McDonald's, and the judge in the US awarded over $1 million in punitive damages. The intention of the judge was to punish McDonald's for filling the cup up, not providing some room for safety, for no hot drink disclaimer, etc. So the idea there was to punish the wrongdoer, and this money goes to the victim if they are awarded. In this case, the McDonald's case, actually, there was an appeal. In the appeal, the appeal court brought this amount down to 700,000, but then McDonald's and the lady, they settled after this, and the settlement details and terms were never disclosed. So those are damages, and most lawsuits, parties, the plaintiff will be seeking for damages, monetary compensation. Usually special damages, some circumstances general, other very few circumstances punitive damages as well, mostly in consumer transactions, for example. Other remedies will be accounting, injunction, specific performance, and declaration. So those other remedies, they are equitable remedies. They come from the courts of equity we discussed last week, last chapter. We don't have those courts anymore, but I told you that those remedies are still there. So you can read more about those remedies, but we'll see them again. in chapter 9. So we'll see what those remedies again, and I'll explain more. For now, I'll just explain declaration. Parties may go to court. So one person may sue the other for a declaration order. For example, if they want to, a child unfortunately just became orphan, and now the grandparents from both sides, they are now fighting for the custody of the child. So one party would sue the other, seeking a declaration order from the court. Who would have the custody rights over the child? The court is just declaring who has a right. Okay? So in terms of monetary compensation, let's say you won the case, you won the lawsuit. So after you won, you have to enforce your award. You have to actually get paid. And there's no guarantee you will be paid. Why not? Well, because it may be the case that the losing party has no assets, no money available, nothing available to pay you. So when the losing party doesn't pay you voluntarily, you can go for this procedure in court known as examination in aid of enforcement or execution. So if you go through this process, it means the court will help you try to find assets that belong to the losing party, because the losing party hasn't paid you voluntarily, nor have they disclosed if they have assets or not. So you would seek the court's help to find assets. In case assets are found, then they may be seized and may be sold, so that the money, the proceeds from the sale, are used to pay the award. If the losing party works, part of their salary, of their wages, may be garnished. Not all, but part. If they have no assets, nothing, you don't get paid. Can they go to prison? No, never. No one goes to prison because they owe money. They owe a court award. No. You may go to prison for a criminal offense. You may go to prison for disobeying an order, a court order, but you don't go to prison because you don't have money to pay a court award. It's just bad luck for the winning party, because they won, between quotations, but they will not get paid. They will not get the money. So when property is found, assets are found, as I said, they are seized and sold. Necessities are exempt from seizure. So if you have a car that you use for work, or the part of your wage that you use for your own living, these cannot be seized. So here I just want to mention to you that there are some orders that can be interim orders. So interim orders are those granted before the trial. There are some orders that are urgent. So let's say in the custody example I told you, the child is now unfortunately orphaned, grandparents are fighting for their custody, and let's say one side of the grandparents want to travel abroad with the child. So the other part would seek an interim order before the trial, so that the child cannot leave the country before the trial until there is a final decision. So now we look at class actions. What are class actions? So this is an action, a lawsuit that is started by one person, but because it is believed that the matter happened with an identifiable class of people, then that party who started the lawsuit will request the judge to classify that lawsuit as a class action. This is very common in consumer transactions. And the idea here is that by having a class action, inconsistent decisions will be avoided. So let's say, remember some years ago when Samsung smartphone or tablet was catching fire out of the blue? So one person could sue Samsung and then request the judge to classify that as a class action because many others who had the same issue with Samsung could opt in that class action and then experience the benefits of any decision. In most cases, actually, the defendants, the companies, they settle because they don't want the bad publicity of facing a class action. Okay, I also have an example here for you. This is real example, BMW. So there was this class action for all purchases of all those BMW types. So 1 series, 3 series, 5 series, etc. So if you were one of the purchasers, if you had a BMW, one of those which is described here, you could opt in for a class action. Okay. So the last part now is regulatory bodies or administrative tribunals. So we started this chapter talking about solving disputes. So disputes may be solved by alternative methods, negotiation, mediation, or arbitration, or court litigation. And then we learn how the court system is and how the court litigation goes. Once you have a decision, the remedies you would seek in court. If you win, how you enforce. We just learned about class actions. But there are also administrative tribunals. Politicians decided like this. Politicians, when they passed legislation, they wanted labor issues, for example, to be handled by boards, by the labor relation boards, not by the courts. The same thing for human rights. They didn't want courts to render decisions on human rights. They wanted a specific tribunal for human rights matters. That's why here in BC we have the Human Rights Tribunal. It is an administrative tribunal which handles complaints, human rights complaints, discrimination, for example. And what is a regulatory body? So I've given you examples of administrative tribunals, but regulatory bodies are those bodies that have to either grant something or will not grant something. So, for example, when you try to register a trademark, the trademark office will either grant registration or not. This is an example of a regulatory body. Another example, the municipality. They are also an example of regulatory body because when you start your own business, you may need licensing. You should seek licensing from the municipality where your business will be located. So they will either grant it or not. Health Canada, another example, and so on and so forth. So advantages of those administrative tribunals, the Human Rights Tribunal, the Labor Relations Boards, they have specific expertise in the matter because they only deal with those issues. You see, judges, they deal with a lot of issues: criminal matters, civil matters, family matters, tax. But those tribunals, they will deal only with the specific matter they were created for. Hence, they are more efficient, they render quicker decisions, and they are less costly. Their decisions are usually, not always, but usually not appealable. The process to render a decision may be reviewed, but not the merits in most cases. Very few exceptions. So again, let's say you applied for licensing to your new business, new company, and the municipality is taking too much time. So this is not correct. So you can use the court, you can sue the municipality, you can ask the judge to order the court, to order the municipality, for example, to decide on your licensing application, either by granting it or not, but take a final decision, take a decision. Okay? And with tribunals and administrative tribunals, there are usually three main aspects for the process to be reviewed by courts. So courts, first of all, they don't like to review process, they don't like to touch upon those issues because they defer the expertise to those tribunals and bodies, but they may step in. They will step in, they will review by looking at the authority of the tribunal, whether the process, the decision making was fair or not, and if there was any recourse in case there was an issue within the administrative tribunal. So in terms of the authority, we have to look at the law, we have to look at the legislation, the statute, the act that created that tribunal or that body. So once that statute gives clear, proper power, there will be no issue. But that authority, that power has to be compliant with the Constitution, has to be compliant with the Charter. And then the fairness of the process. This is very important. Why? Because all tribunals, regulatory bodies, they have to comply with fairness. They have to comply with what is called rules of natural justice. And those rules, they are understood as fair hearing. The decision has to be made by the person who heard the evidence, and the whole process and the decision has to be impartial. So courts, they can change the decision of a tribunal or regulatory body if they find that there were issues, errors, complying with rules of natural justice. And those principles of natural justice, they are also applicable to private companies. So when an employee is accused of harassment, for example, they are entitled to a fair hearing, to an impartial investigation. So that's important for all of us. And when the courts review the decision, review the decision made by those tribunals or uh, regulatory bodies, they will mostly, as I said, review the process, not the merits itself. Very, very few exceptions in which the merits, the decision may be reviewed. Why will they review? They will review if they find that the statute that gave authority to that body is invalid, or the remedy or the decision goes beyond the power, if there were errors of law, if there was abuse of power, partiality, so they may review. So I know this was a long chapter, but both chapters 2 and 3, they are fundaments, they are um, important concepts that we will be using throughout this course. So you need to understand concepts of law, sources, origins, systems, and also how disputes are solved, the remedies, enforcement. So that's it I wanted to share with you in this chapter 3. Thank you.